commercial speech occupies an uncomfortable place under the First Amendment. For most of the nation's history, it received no protection at all. As this quote from Gordon Wood indicates, the self-promotion and profit-driven decision-making inherent in the commercial marketplace offended cherished American ideals about what a good citizen of a republic looked like. Commercial activities were considered inferior to participation in legal affairs and public policy, and thus judges and other leading thinkers typically did not consider commercial speech worthy of the same protections the Constitution extended to political or cultural speech. In recent years, this view has been articulated more formally by scholars trying to convince other nations not to follow the American example and to continue treating commercial speech as an unprotected form of expression. The Baker thesis is a typical statement of this view. In essence, Baker argues that commercial speech seeks to make money, preserve the economic power interests of the status quo, and present factual information about consumer products in ways that do not invite response or debate. By contrast, political or cultural speech expresses the interests and liberty of actual people who engage in public debate to test their ideas and challenge the holders of power. These two kinds of speech, according to Baker and others in this line of thought, are so different that the law should not treat them as the same. However, American law since the 1970s has departed from such attitudes toward commercial speech and recognized that information about products and services is essential in an economy in which most such services are bought at a distance from someone the purchaser will never meet. In more recent cases, the Supreme Court has consistently reaffirmed that the importance of this free flow of information justifies protecting commercial speech under the First Amendment. At the same time, the High Court has acknowledged that commercial speech is not as important as political or cultural speech, and it thus can be restricted by the government more easily. A difficult threshold problem is defining what qualifies as commercial speech, especially as advertisers increasingly mingle commentary on cultural and political issues with appeals to buy their products. Should such speech receive full First Amendment protection, or is it simply an attempt to evade the lesser protections given to commercial speech? Two leading cases have attempted to define commercial speech, and these definitions are widely used by other courts. Specific facts in each case, such as the motive for distributing the speech or the potential audience for the message, are crucial to determining whether the message is commercial speech or is fully protected cultural or political speech. If the message is determined to be commercial speech, the court conducts a two-stage analysis known as the Central Hudson test to determine whether the government can restrict that speech without violating the First Amendment. In the first stage, the court will ask whether the commercial message is factually false, misleading, or designed to facilitate a crime. Thus, for example, a commercial message advertising a casino in a state where such gambling establishments are illegal would lose all First Amendment protection. Note that this is very different from the way the courts treat cultural or political speech, leaving it to the marketplace of ideas to punish false statements. If the commercial message is not false, misleading, or unlawful, the court applies a test similar to intermediate scrutiny to determine whether the message can still be restricted. If the government can show that it is restricting this commercial speech to advance a substantial or important interest, that the speech restriction directly advances this interest, and that the government is restricting no more speech than reasonably necessary to advance its substantial interest, then the government can restrict the commercial message. No First Amendment violation is committed. Such content-based restrictions would trigger strict scrutiny if they were applied to cultural or political speech. Thus, the Central Hudson test illustrates that commercial speech receives less First Amendment protection than other kinds of speech. In the 44 Liquor Mart case, the Supreme Court held that restrictions on advertising the price of alcohol products violated the First Amendment. The court reasoned that even if it accepted Rhode Island's argument that it had a substantial interest in deterring excessive drinking, the state's regulations were not a reasonable fit to that interest. The state had other means of limiting alcohol consumption that would not require restrictions on speech. Similarly, in Lorillard Tobacco Company versus Riley, the Supreme Court voided state regulations against tobacco advertising. These regulations essentially banned tobacco advertising in most of the state, and thus would keep the vast majority of the state's residents from receiving information about these products. Despite the state's interest in preventing children from smoking, the court ruled that its tobacco advertising restrictions were not carefully tailored enough to be a reasonable fit to that interest. In a recent case, the Supreme Court has indicated that commercial speech restrictions cannot be applied to one viewpoint while another viewpoint is allowed to speak freely. Thus, it would seem that commercial speech regulations must apply equally to all commercial messages on a category of product or type of industry. The Supreme Court's rulings on commercial speech provide the basis for Congress to regulate the most common kind of commercial speech, advertising, without violating the First Amendment. It should be noted that just as not all commercial speech is advertising, not all advertising is commercial speech. Advertising that promotes or attacks political candidates or advocates a position on public issues does not fall within the government's authority to regulate commercial advertising. The speech expressed in advertisements about political opinions, rather than advertisements that promote a commercial business, receives full First Amendment protection. Commercial advertising is regulated at the federal, state, and local levels. Some agencies, such as the FCC or the FDA, only regulate advertising for certain kinds of products. The Postal Service charges higher rates for advertising heavy mailings, and numerous local governments restrict the methods of advertising to avoid annoyance or inconvenience for their residents. Additionally, reputable advertisers and advertising agencies police themselves to avoid damage to their reputations. The news media play a significant role in exposing false or misleading advertising. Federal legislation authorizes companies to sue their competitors if a company has lost sales because of a competitor's false or misleading advertising, and legislatures in most states have passed statutes authorizing the state attorney general to sue on behalf of the public over false or misleading advertising. The main source of direct regulation of advertising content, however, is the Federal Trade Commission, which can warn advertisers that their practices are unlawful, order them to remove such ads from the public eye, and impose fines for serious violations. Advertisements whose messages are false or related to committing crimes are easy enough to spot, but most issues before the FTC deal with advertisements the Commission believes may be deceptive or misleading. The FTC applies a three-part definition to determine whether an advertisement is misleading or deceptive. First, there must be a material representation, omission, or practice to be assessed. Material means the advertisement has made a claim that is likely to affect whether a consumer buys the product. Material statements do not have to be made explicitly. Thus, for example, the fact that a speaker in a television ad was dressed in a white lab coat and surrounded by medical charts as he promoted a health product was found to be a material representation. The fact that the spokesman was in fact not a doctor satisfied the second part of the FTC's definition. The material representation, omission, or practice must be likely to mislead a consumer. Likely is assessed on a sliding scale, depending on the FTC's view of how sophisticated the advertisement's intended audience is about advertising and media. Two kinds of false statements will not be considered misleading. First, puffery, or claims of pure opinion, such as, "This product is the best, you'll love it," or "This product will change your life," are purely subjective and don't imply particular facts about a product, so the FTC will not find them to be misleading. Second, claims that are so outlandishly false that no one would take them literally will not be found to be misleading. Thus, for example, an advertisement for a brand of golf balls that claimed this brand will send your drive into the stratosphere was found not to be misleading. Finally, as in many other areas of law, the hypothetical consumer must be acting reasonably. The FTC tends to assume that the consuming public is quite savvy about advertising techniques and skeptical of their claims. Thus, the fact that some gullible or inattentive consumers were misled does not by itself prove that the advertising was deceptive or misleading. Only if the material statements would be misleading to a reasonable consumer will the advertising lose its First Amendment protection and be subject to punishment by the FTC. FTC Chairman John Leibowitz recently discussed the agency's efforts.
How do you share with advertisers and manufacturers what the rules are?
It basically boils down to just a few rules, and they're sort of common sense rules, and advertisers know this. And one is, make truthful claims. Another is, don't make misleading claims. And another is, you better be able to substantiate your claims.
What have been some of your successes?
We recently had a settlement with Oric, the vacuum cleaner manufacturer. Oric claimed that they had a vacuum cleaner that would reduce incidence of flu, a flu-reducing vacuum cleaner.
Laboratory testing showed that it killed up to 99.9% of flu virus and E. coli bacteria in less than 1 second.
Scientific proof. There's been a change in your standards for scientific proof that a product works. Can you explain that?
Well, there are studies and there are studies. So some studies are really well done by scientists, and some studies, are done by people who have, and some studies are done by people who may be doctors, but doctors of philosophy. So how can they tell you that, how does that make them qualified to tell you about, say, a dermatological remedy or a skincare remedy, right? I mean, good companies will have real studies. Fly-by-night companies or bottom-feeding companies, you look at that so-called substantiation and, it's a joke.
What are the rules about testimonials?
Very often, someone will say, I lost 80 pounds, or 40 pounds using this product. And if they put a little tiny bug at the bottom or a little tiny sign at the bottom for, a blip or a nanosecond or a portion of a second saying results not typical, that doesn't inform consumers.
So given the profit margin in the infomercial world, the fines you can assess are just a drop in the bucket and probably just a risk that these companies are willing to take.
Certainly some of the bottom feeders are willing to take the risk because obviously we can't go after every example of false advertising in the marketplace. And the penalties we can assess are less, even against the companies we do go after, are less than we'd like it to be.
The substantiation Leibowitz referred to is the requirement that advertisers must have evidence for their factual claims. Not necessarily hard scientific proof, but at least a reasonable basis for making statements about the advertised product. Additionally, the advertiser must have this evidence in hand before making its advertisements public. Unlike in libel, where a defendant can catch a lucky break if his published statements turn out to be true, the advertiser is not protected just by the truth of its claims. An advertiser who did not have evidence that its claims were true before publishing its advertising is still subject to punishment by the FTC. The evidence must be adequate to support specific claims made in the advertising, and the advertiser also must have evidence for any reasonable inferences a member of the public might draw, even if the advertising does not state those claims explicitly. If an advertisement could lead a reasonable member of the public to a conclusion that isn't true, the advertiser is responsible for clarifying that point in its advertising. Unlike advertisers themselves, the publishers of advertising, such as newspapers or television stations, usually are not subject to any penalties for false, misleading, or unlawful advertising. This protection can be lost, however, if the publisher knew the advertising was false, misleading, or unlawful, and especially if the publisher created the advertisement on behalf of the advertiser. Ad publishers are wise to protect themselves by including a clause in the advertising contract that requires the advertiser to promise that the ad is entirely lawful and that the advertiser will pay any fines or legal costs imposed on the publisher. Additionally, the publisher's staff, such as the advertising design staff commonly employed by newspapers and magazines, should strictly adhere to the advertiser's content and instructions. If the publisher's staff create content for the advertisement, the publisher can be responsible if that content turns out to be false, misleading, or unlawful. Additionally, publishers have a virtually absolute right to refuse advertising, except for over-the-air broadcasters who can be required to sell certain kinds and amounts of political advertising. Laws and regulations against false, misleading, or unlawful advertising also apply in new media, although they can become more difficult to enforce. Including misleading headers in spam emails, for example, to deceive the recipient into thinking the email is legitimate, can violate federal regulations. Banning such emails entirely probably would be held to be an unconstitutionally broad content-based speech restriction. Similarly, deceptive search engine results that try to mislead consumers away from the site of a business they intended to visit can be deceptive commercial speech, and also can infringe the trademark of the company whose site is being mimicked. Commercial speech through telecommunication devices is even more heavily regulated, since those devices fall into much the same First Amendment category as over-the-air broadcasting. And collecting marketing data on children during commercial transactions is severely restricted.